Hi, I'm Adam Whiting. I'm an intellectual property attorney at a firm called Fisher Broyles, and I'm going to talk to you today about sort of a tutorial and overview of the basics of intellectual property law. I've called the presentation Intellectual Property 101, as you can see here. And what I'm hoping that you can get out of this is just some of the major features of intellectual property law, what you should be thinking about, and maybe some resources you can go to in the future. Um, a quick background is that I'm originally a scientist, and then I got into intellectual property law in about 1998, and I've been doing it ever since. I've went to law school, became a lawyer, and mainly what I do now is I help small companies, particularly in the biotechnology, life sciences, pharma area, get patents that help them basically get investment and protect their inventions. So I will proceed with the big general question that most of these sort of tutorials would start with. What is intellectual property? I think we all know about real property, which means land. And there's some similarities to intellectual property and how we sort of constrain it and define it. Uh, Generally it's covers intangible creations of the human intellect. And there's four main forms of it that you've probably heard of. The main ones are copyright, which we're all familiar with in some ways, but is actually pretty complicated when it gets down to the legal aspects. There's trademark, which is really associated with goods and services that people sell in the marketplace. Trade secrets, which in some ways is very simple. You just have to keep things a secret. And then the other side of trade secrets is patents, which is a government granted right for a particular term that allows you to sort of have exclusivity over your inventions. Okay, I guess we're jumping into, and I hope I didn't proceed too far there, yeah, into some copyright hypos, which means hypotheticals, and these are the types of things that help us understand legal uh, legal ideas. I thought this one is a fun one to start out with. Can a chimp have a copyright in a photograph it took itself? And here's the hypothetical. The chimp picks up a photographer's camera, takes a selfie. The photographer includes the photo in a coffee table book, but then an animal rights group sues the photographer on behalf of the chimp. Did the photographer infringe the chimp's copyright? So interesting question. And the answer, I guess, is that no. It turns out that the U.S. Federal Court of Appeals decided that copyright only applies to human-made works. So that's a quick answer there, but maybe good to know next time you're handing your camera to one of your pets. Uh, One below it I thought was interesting was a graffiti artist might paint something on a building. Does the graffiti artist own copyright in the mural? The answer is yes. The graffiti artist has created a copyrighted work of original authorship by painting something on the building. Uh, and if someone were to copy that, the graffiti artist would have an action of copyright infringement against the unauthorized copy. The graffiti artist might not want to come forward since they have also vandalized a building and could be liable for that. Uh, and can the building's owner paint over the mural without graffiti artist authorization? Under copyright law, I believe they can. But there are other laws associated in different places with an artist's rights to their work. So um, I think once again, it's kind of a bit of a crazy hypothetical, but it gives you a sense of some of the complexity of copyright law. So we've covered a little bit about copyright here. And here's sort of the general definition here on slide 4. It protects original works of authorship as soon as an author fixes the work in a tangible form of expression, meaning writes it down, paints it on something. It can't just be an idea floating in the air. It has to be tangibly put down. So I'll move on now to trademarks, and trademarks are any word, phrase, symbol, design, or combination thereof that identifies goods or services that are sold in commerce typically. Some interesting trademark ideas, or once again, situations that people may not know about. You can obtain a trademark in a color. And Tiffany, the jeweler, has a trademark on its distinctive blue color of its boxes. Similarly, you can even obtain a trademark in a scent. Apparently, Play-Doh has trademarked a scent of their product. But you should note, trademarks are really limited to the specific goods and services. So that blue color of the Tiffany boxes, that doesn't mean you can't use the blue color somewhere else. But if you were selling jewelry and you use that blue color, Tiffany could probably come after you. So once again, trademarks are limited to specific goods and services typically, and also the location. So if often trademarks will be regional, that is, small companies may have a trademark to a certain product name in part of the country and not in another part. And I think that's true with Breyers ice cream and Dreyer's ice cream, which we have out here in California. Now I'm going to move on to sort of trademark and copyright are both important, but I don't really specialize in those or work in them too often. I pass that work off to my partners who sort of specialize in those things. I'm a patent attorney for the most part, and so my clients, I'm usually helping them get patents on their inventions. And patents are quite a bit different than trademarks or copyrights. First, I'll talk a little bit about trade secrets. So patents and trade secrets are sort of, I guess, two sides of the coin. A trade secret, it's any information that derives economic value from being kept secret and is the subject of reasonable efforts to maintain its secrecy. And so often companies, they may not or want to file a patent application on something, because if you file a patent, it gets published and then everybody knows. That's part of the trade-off. If you get a patent, it covers something for a limited amount of time, gives you exclusivity, but you're also sort of disclosing that invention out to the world and how you make it. And there's benefits to that, but you may just want to keep it secret. So often formulas, processes, techniques, even types of data, anything that's economically valuable information can be a trade secret. But if it's something that can be, I have a note here, ascertained by proper means, is not a trade secret. So, somebody can buy one of your products and reverse engineer it, and you don't have a patent on that, it's simply a trade secret. Well, they can go out and make the same thing. There's no protection if it's something that can be ascertained under legal means. And sometimes companies will have, if they sell you something, they'll have some sort of terms and conditions with it that you can't reverse engineer it. For example, software, things like that. Let's see. So trade secrets have their limitations. The main thing is you must keep it a secret, and you must take reasonable measures to do that. You can't just tell anybody what it is and expect to be able to have the rights of a trade secret. So you have to do things like keep it limited on a need-to-know basis to certain people within your company. You have to write down what it is and keep it in a safe. Make sure you define what the trade secret is. So here in this slide, I'm going to sort of talk a little about why or why not you should have trade secrets. Uh, Trade secrets and patents, as I mentioned before, are sort of two sides of the same coin. They're mutually exclusive. Patents are not secret. They're published. Uh, they teach people how to make your invention, but they define sort of your property that you have an exclusive right to for a limited term, usually 20 years. Trade secret may be a better way to go. It doesn't expire. You can, as long as you keep it a secret, uh, you can always protect it. And the great example of that is the Coca-Cola formula, which apparently has been maintained as a commercial trade secret for over 100 years. You may want to use trade secret protection when it's something that if you did sort of, it could be easy to design around, something that would be hard to protect with a patent. It may be better to just use trade secret. And something like a formula where it'd be easy to just change, you might be able to get a patent on a particular formula, but for example, for Coca-Cola, but it might be easy for somebody to just manipulate that a little and get something that was nearly as good, and they could go to market with it. So you might just want to keep it a trade secret. And I note the risks down here. If it gets out, anyone else can use it. There's no exclusivity. That is what is associated with the patent. And somebody else could get a patent on your trade secret once it gets out, or if they just happen to independently come up with something that is similar, they may get a patent. And in fact, that patent may prevent you from using your trade secret. That is, if they know you're using it. So trade secrets are interesting. With my clients, I'm usually helping them get patents because there are risks, as I just mentioned. But here's a few famous trade secrets that we've all heard about. Coca-Cola formula. I mentioned that supposedly only 2 executives know the formula at any given time. And similarly, we have a Kentucky Fried Chicken here, the original recipe. Once again, they keep it a secret. When they produce it, they have different companies, contractors making the different parts of it, and only a few undisclosed employees know the ingredients. So enough about trade secrets. Let's move on to patents. A patent is a property right to a claimed invention, and that word claimed is really important. But that invention is granted by governmental law. So it's all federal law when we're talking about patents. Patents are included in the Constitution. And so they're part of our federal system. Most people like me who are patent lawyers, we're dealing with federal law. There's no state patents, whereas with trademarks, there are state laws regarding trademarks, similarly to trade secrets, but patents are purely a federal legal construct. The boundaries are limited to the claimed invention, not to the patent application's disclosure as a whole. I'm going to show you a little bit more about patent applications, and there's a whole document, but it really comes down to the very end of the document. There's these specific sections that essentially define the limits of your invention, and those are the claims. And the claims are the name of the game, as we say. And I mentioned here, it's usually much more limited. You may describe a broad range of uses of your patented technology, but really what you can have power to exclude others from doing is defined by those claims. Patent rights are limited, 20 years from the filing date, and they're also limited to countries. You can only enforce a US patent in the US. If you want to go after people in Europe, you have to file a patent in European countries or other parts of the world. And in fact, I do that quite a bit. I work with attorneys in other countries because many of my clients, they want to be able to protect and market their inventions in other countries. So patents, often it's brought up, why do we need patents? Why have them? They just seem to get in the way. Uh, well, I'll give you a few of the standard policy reasons. Uh, they provide the owner with this sort of market exclusivity. And in fact, the main reason is that we see that exclusivity as providing increased profits for the person who invents it, but that it also incentivizes innovation. That is, if you can come up with something new, novel, non-obvious, you can get a patent on it, and you're going to also have to publish that patent, and it's going to create this marketplace of new ideas that after the patent is expired, people can go out there and use those ideas to invent new things. They can essentially stand on your shoulders. And so fostering innovation is one of the big motivations behind having patents. So patents require disclosure of your new innovations rather than keeping them secret. And the disclosure is actually sort of the price the inventor you have to pay to get that exclusivity from the government. That is, if you don't disclose everything, the way somebody can make and use your invention, your patent may be found invalid. So part of the deal, the tit for tat, as they say. And once again, yes. Businesses, this is how they see things, the reason to have patents. You keep competitors out of your field potentially. You could protect specific products and processes, once again, for the 20-year term. Patents are also used almost as a sort of a way to attract investors by showing that you have invented something and that you have that sort of capability. So you're showing that you're doing research, you're developing new products, you're showing leadership. It gives you also, I have here, IP to cross-license with competitors, and that's often big in that your competitors may have patents and they may threaten to sue you. Well, you have patents too. You can threaten to sue them back. So there's this sort of way of viewing patents in a lot of industries is that you got to have some of your own to go after your competitors so they won't go after you, sort of mutually assured lawsuits. And as I mentioned here, you may be able to license your patents to others, or it's also important to attract financing. In the area I work in, biotechnology, usually it may be 10 years before there's an actual product, and you're just getting money from investors. You need to know that you can promise your investors, well, we're going to have some exclusivity going forward on our research and development. So it will pay off and keep giving us money so that we can get there. So it's often misunderstood maybe what the rights a patent provides. So I'm trying to address that here with these points. A patent only provides the right to exclude others from making, using, offering to sell the claimed invention. Once again, that claim for a limited time. It doesn't necessarily, and here's the sort of the part that people often don't appreciate. Owning a patent does not necessarily mean you have the right to make, use, or sell the claimed invention. And it doesn't guarantee freedom to operate. So you may get a patent on your invention, and there may be another patent out there that is broader that will also cover your invention. And if you cannot have a license or permission from the owner of that patent, you technically could not practice or do whatever you have claimed with your invention. You could prevent others from doing it because you do have that claim. But that's the point I make here. It's dominating or blocking patents owned by others may exist. You may need a license to make, use, and sell your patented invention. So, how do that doesn't seem right. Why would you need to go out there and carefully review and monitor the patent landscape, as I call it, for potential obstacles. That is other people's patents. It may turn out that I do this all the time for clients. They're working in an area, they're doing novel new research on something, but they have to worry about there may be other people out there who have patents that cover some aspect of what they're doing, and they need permission from them. So that's what we call freedom to operate analysis. I will search for patents, and then I will look at their claims and hopefully be able to assure my clients that, yeah, as long as you do this, you will not be covered by their claim. You do not need to get a license from them. You have freedom to operate in doing this. So a lot of people will say, well, we have a patent on that, so we can do that, right? Well, not necessarily. And anytime you're getting close to having a product that you're going to sell in the marketplace, it's good to have a patent attorney look at if you do have freedom to operate, especially if you know that there's close competitors in that area who are also filing patents. I talk a little bit more about freedom to operate in this slide. Once again, it's a legal determination. You have to really know exactly what it is that you want the freedom to do and where you're going to do it, because that can be a factor. Often companies will they'll manufacture part of a product in a different country if they know that there's not a patent there, and then import it to the United States, or there's all sorts of possible ways you may try to get around a blocking patent. But at the end of the day, you really have to have an attorney look at this, because it can be tricky understanding the words of patent claims, and we'll look at a few patent claims here, and they may be more limited or broader than you think. I have a note down here. Beware, in US patent litigation, everything is discoverable. And that's for a lot of my clients, that they should know that if you are sending emails internally or things of that sort where you're talking about other people's patents, and you're saying you don't want to say anything in those emails that is going to be used against you in a case going forward. So that's part of the world of patent law, is really being aware of other people's patents and make sure that you are being diligent in avoiding them and having your attorney look at them. With that said, let's look at a few patents. There's the main features of a patent are outlined in this slide. There's always an abstract at the beginning that's, hopefully a little easier to understand and gives you the general idea of the area. You have to have a background section where you describe what may be considered the prior art. Prior art is a term we use all the time in patent law. It's describing everything that's been done before, inventions that are already out there, or descriptions in the literature. You're supposed to sort of describe that a little, and then you have a summary of your invention. You have a summary, a description of the drawings you may decide to use. They're not required. In the old days, 100 years ago, you had to actually have a model built of your whatever it was you were trying to patent. And I guess in DC, you can visit there's a museum of a lot of old patent models from the 19th century that is fun to go to, or at least for those of us in patent law. And then a detailed description where you really have to define what your invention is, show examples of how it's done. And that's especially important in these sort of biotechnology, life sciences chemistry that I work in, if you don't show working examples, you may not be able to get a patent, although technically they aren't required. And then, of course, the claims, which I've already mentioned. And we say the name of the game is the claim, because those are really where the rubber meets the road with defining what is the property rights of the patent owner. Property boundaries of a patent are defined by the words of the claim. So it's words. And I spend a lot of time thinking about what words to use to describe an invention in a claim. Each claim is a single sentence that describes the patent and invention. These sentences can be quite long, as you'll see. Each word is presumed to contribute to the scope of the invention. So you want to have it as concise as possible. Every time you add another word to a claim, it's potentially a possible it's adding or narrowing the scope of the claim, which could give a competitor some way to get around your claim, to design around it or avoid it. We have what are called independent claims. Claim 1 in a patent is usually the broadest claim, the broadest property right. But then there's many other claims typically that are dependent from claim 1, where they add other words that narrow it down. And it's sort of a strategy. You want to have sort of narrowing claims, because there may be reasons that, your broadest claim seems like it would be the best one, but it may turn out in the future there's discovery of prior art that you didn't know about that makes that claim 1 invalid. And so that you have sort of a backup position in these narrower claims that can be very valuable. I'm going to show in the next slides a few examples of claims. I started here. This is a claim for a client I've done some work on, and they have plant-based proteins that they are putting into non-dairy beverage products. And this would be a typical claim that in one of their patents, you can see claim 1 here, a refined protein component obtained from a plant source comprising. And comprising is an important word that you'll see in claims. It means including, but not limited to. So here we see the list of things that are defining this refined protein component. It has to have about 70 to 90% by weight of protein, 0.1 to 2% by weight of calcium. It is from an alkaline extracted plant source, and the refined protein component is insoluble in aqueous solution at a pH less than about 6. So that's still, a little more chemistry than maybe some of us are used to. But basically what I want you to see here is that we have each of those lines there that are part of this claim have been put in to help define this invention, which is a particular material, a composition of matter, a protein. And they may have been added because we discovered there was prior art, or that it already out there that didn't include all these elements. And so we had to add these in order to sort of get our claim allowed by the patent office. But hopefully each of those limitations are defining this piece of property. And if somebody out there makes a refined protein component from a plant source that has all those same limitations, we can exclude them from doing that. And the comprising language, once again, it means if they have all those things, and they have other stuff, for example, some other component that's not listed there, they still will infringe this claim, and we can exclude them from doing that, because comprising is open-ended. It means including but not limited to. And it's important as you look at patents to understand that, and you look at the claims. And I'm put down here a few dependent claims. because as I mentioned before, those are always part of a patent property. Claim 4 here, it says the refined protein component of claim 1 comprising less than 10% by weight of fat. So that's just saying here's another property boundary in claim 4. It's everything in claim 1, plus it also has less than 10% by weight fat. And similarly, claim 6 further defines claim 1 as having a particular color. And one of the interesting parts about this particular composition is that it maintains a very light color. Some of the plant-based protein products that are dairy substitutes, they won't be white basically. And so you want to have something that maintains that sort of light color because that's what customers want apparently. So, okay, I've shown you a little bit of sort of the, I guess, food chemistry that I've worked on in the past. Here's one that's maybe more relevant, and I just searched, and I'll tell you a little bit about the sort of resources online you can use for searching for patents. But I searched for forestry, and I saw some recent patents, and this is one that is related to arboriculture safety monitoring device, which seemed pretty relevant to the sort of mission of the Northeast Center, which is about fostering innovation and safety in forestry, farming, fishing. And this is just another example of a claim, and this was from a US patent. I think the patent owner was Husqvarna AB, which I guess is a Swedish company. I know they make chainsaws. But anyway, here's a claim. You can see it's a lot longer and detailed, but an arboricultural safety monitoring device comprising at least one proximity sensor, alerting means, at least one carrier on which the at least one sensor is arranged, a controller, and a communication interface. The arboricultural culture safety monitoring device being configured to, and then it's even more limitations. And all of these things are defining this invention. And each and every one of these words you have to look through as you're analyzing, for example, whether or not your arboricultural safety monitoring device would infringe this claim. Does it have all these elements, all these limitations? It would need to have all these in order to for the owner of this patent to say it infringes. If it doesn't have any one of them, then it's outside those claims. But this just gives you a sense of, first of all, there's millions of patents out there. They're being filed every day. Companies are trying to cover and gain protection for their intellectual property. And here's an example in the area of forestry safety monitoring. There's probably a lot more like these, but you have to look at each and every one of these claim terms to really get a sense and understand what is the scope of this. And, this is what I do for a living, but a lot of people find this a bit, intimidating. And in fact, it is the first time you're looking at these patent claims. There's a lot there. So once again, a patent can be very important and help protect your inventions, but it is involved, and it's probably good to get the help of a patent attorney. If you're moving towards commercialization or hoping to get investment and you want to protect your particular inventions. Here's the sort of second part of that last slide showing the dependent claims for this arboriculture safety monitoring device. And once again, in searching for patents, you'll see the language they used here in these claims, arboriculture. I guess that's, why didn't they say forestry? Well, maybe they decided they used this word was the patent attorney decided was broader or could be interpreted in certain ways. And basically, when you write a patent, you can sort of use any language you want, but if you define it in the patent. It also makes it hard to sometimes search for patents because if you're searching using the term forestry and you should have been using arboriculture, uh, you're not going to find this patent. So it goes to show you that there's a certain art to searching these things too. But I would encourage you to go out there and search for them and go to Google Patents. I'll show you a link at the end and search in your area. Just enter some keywords and see what you find. Follow some links. And it's very important to do that before you file your first patent because you'll be surprised. Very often clients come to me and the first thing they'll say is, I think we should file a patent application on this. I've never seen one of these for sale anywhere. And it turns out that even though something you don't even haven't seen it in the marketplace, somebody may have filed a patent application and there's a good chance they did that covers it, especially if it's a relatively simple idea. It may be. And so before you go and spend thousands of dollars filing a patent application, do some searches, see if you can find. It may that it's be in an old patent that is expired. The patent is not going to be a problem for freedom to operate because it's expired. But because it's prior art, it's already described out there, you won't be able to get your own patent granted on it. So before you waste money going out there and trying to patent something, it's good to do some diligence, some searches on your own. And that's, people can do that. And I encourage a lot of my small clients to become comfortable in searching and finding out what's out there. Along those lines, a few things you need to understand about patents. There's patent applications and there's granted patents, or sometimes they call them issued patents in the US. Patent applications are the application that you first file, and they're not enforceable. They have claims in them, but those claims have not been granted yet. And they often are much broader and essentially they have no legal rights associated with them. The patent application is this initial disclosure, this description of what you think your invention is that is submitted to the patent office. Typically, the claims in that patent application are much broader. It's kind of before the patent is examined, and what happens during an examination is the patent claims will be narrowed. You have to amend them. They'll say, no, that's too broad. Look, there's already this prior invention. You need to limit it more. So patent applications will show up in searches. You do a Google patent, and often clients will find them and they will say, oh my God, there's this patent application here. And then if you look a little more closely, you'll see, oh, well, that patent application is not granted. In fact, you may find that it was abandoned. Somebody filed it. They decided they didn't want to continue with it, paying fees, or they discovered there was some prior art that wouldn't allow them to get a granted patent. So you can sort of discount a lot of patent applications, although they are disclosures, so they will be prior art to things you try to file later. And down here, I have granted patents are enforceable until it expires. And this just, once again, defines the fact that patents are limited in time. You also have to pay fees to keep them alive. And for example, in the US, you have to pay every 4 years a certain amount of money to keep that patent alive for the full 20 years. So they do cost money. And I have a little note down here. Google Patents does a pretty good job of showing the term for granted patents and indicating whether or not they've expired. I've also noted here the patents can be invalidated if somebody tries to sue somebody with a patent. the defense is to say, oh, their patent is no good. It's invalid because, look, we found this earlier description of this invention. That's prior art, and therefore they should not be entitled to that patent. Uh, or there's could be other reasons. There's also ways to oppose patents uh, in the patent office. An inter partes review is commonly used. Uh, so it's part of patent law. The area I work in is not just helping people get patents, but also sometimes suing people with patents, litigation, what we call patent litigation, and also defending people from being sued. And that can involve challenging patents or invalidating them. And I have a few more, I get down a little more into the details of what's the difference between a patent application, a granted patent. Basically, in the US, if it has an A, or other places in the world, you'll find when you search Google patents that you'll see patents from all over the world. The A designation, whoops, get back, the A at the end of the number, like here's an exemplary number here, means that it's just an application that's been published. It's not granted. Once it's granted, it typically has a B afterwards. And that would be like this down here, 1, 2, 3, 4, 5, 6, 7, B2. That's a granted patent. So when you see that, you know, oh, well, I have to look at the claims to this one, and these claims are potentially enforceable. And obviously, a granted patent is much more valuable than a patent application that's published. A patent application, I'll often tell a client, is just sort of somebody's wish for what they want to have as their intellectual property. And it's really the granted patents. Those are the ones you have to look at carefully, or you're trying to get. And you know, they are enforceable. And here's just an overview of sort of a timeline that I would generally give people an idea of getting a patent, what it takes. It's usually, and this graphic here, this schematic, is showing typical steps in getting a patent that I go through. I have here on the left, there's the priority filing. Often in the US, we'll file what's called a provisional patent application. It's a patent application that is not examined. It's cheaper there's lower fees in filing it at the US Patent Office. It sort of sits there for a year, and it's mainly marks as what we call a priority placeholder. It gives you that early date. But it's, you know, the date is only relevant to what's described in it. So often people will think you can just file some one quick and dirty patent application and it will protect you. But at the end of the day, a priority US provisional application is really only as good as what's disclosed in it. But it can give you an early date. Often my clients will file that. Then within 12 months, they have to file what's called a non-provisional application. That's an application that will be examined or lead to examination and can lead to a enforceable patent. And so that's sort of 12 months out. This next thing here, publication of application at 18 months. That's now around the world, that's true. So once you're 18 months after your earliest priority filing, your application will be filed or will be published in the United States or in other countries where you file it. And when I say published, nowadays with the internet, with the databases like the Google patents, you will see those right away. And so your competitors will know what you're working on. And by the same token, you'll know what they're working on because it's published. So you should think about that. Once again, getting back to the idea of trade secrets and things like that. Do you want this published within 18 months? There's pluses and minuses to that. And of course, the plus here is that if you want to get a granted patent that you can use to provide exclusivity, and you got to let it be published. Then I have here the next sort of big deadline that's commonly used is 30 months. And that is really this national phase filings. You'll notice under non-provisional filing, there's something here, PCT. That's a patent cooperation treaty application, which is really another way, it's a name for an international patent application. And most companies that want to cover their inventions, they usually want to cover them not just in the United States, but possibly in other places, Canada, Mexico, China, places where they may be made, manufactured or imported from. And so it's important. Often I will file a PCT application, and that application is sort of a placeholder for this 30-month deadline when you can file that. You can turn that PCT application into national applications in various countries. You essentially convert it. And so you can see here, national phase filings at 30 months. You can see we filed in the US, we filed a EP, a European regional patent that can go into many national patents in many countries. And then Australia, Japan, all these places. And you can decide only to file in the US. You don't have to file in all these countries, but the PCT application, that international application, really gives you this option. And it's sort of the a way to give you another 12 months or 18 months to decide what you're going to do. Because when you do file in these countries, you're going to be paying money to file in each one, and it can get expensive, particularly if you go to a country like Japan, where you have to translate your patent from English into Japanese, or in China. Typically, it's most of the patent applications for my clients, when we file them in Japan, that's $5,000 in translation fees right there. So it's big costs, but it may be worth it. And finally, the final box here, the granted patent, that's, as you can see, 3 to 5 years in the US. The US goal of the US Patent and Trademark Office is 36 months, but often it takes longer than that. And in the rest of the world, places like Europe, maybe 5 years before you have a granted patent. So that's something, to keep in mind. Is it worth it? In some industries, the market is changing so fast, products become obsolete quickly. And so it may not be worth it to file in some countries if it's going to take a long time for the patent to be granted. Things are going to have moved on anyway. So there's maybe less patenting, but in the areas I often work in, like I said, the product may still be in research and development for 10 years before it's actually on the market. Here's a slide where I just go through a PCT application, something I just sort of talked through. They're international applications. They allow you to file national applications in many different countries. And yeah, it's very common for my clients that at the end of 12 months, we will file as a non-provisional a PCT application. So it gives them the option at 30 months of filing in all these countries or not. Okay, near the end here. I provide this slide just to give you an idea of the kind of places you can go to look at patents, to search for them, and maybe help you as you begin sort of the initial diligence process of, gee, should we file a patent application? And maybe get ideas. People use the patent databases just like any other literature source to get ideas on improvements to their own technology, their own inventions. So here, PCT and US applications are always published on Thursdays, 18 months, as we mentioned, after the earliest priority date. Granted patents are always published on Tuesdays in the United States. So set your calendar. Anyway, you can go to these free searchable databases. And the one I use a lot, and it's become really good in the past 10 years is the Google Patents database. And I would encourage you all to just go there and check it out, enter some keywords and see what you find. It's a great way to keep up with what's going on in your area. You can set up search terms that are provide results every week, that sort of thing. These other ones are a little more specialized. WIPO is the World International Property Organization. They have their own database. The European Patent Organization has a database, and of course, the U.S. Patent and Trademark Office, USPTO database. So, in summary, I guess here this is a question that comes up with clients. Should I patent it? Should we publish it? Or should we just keep it a trade secret? And sort of, this is just sort of a rule of thumb slide. I would say trade secret is good to use if it's valuable information, but it's not really suitable to patenting and is not readily ascertained. That is, somebody can't just look at your product and figure it out, the method that was used. And often that would be a secret formula in making something, or something, the method of manufacturing it in your factory or wherever. There may be tricks to doing that. And if somebody can't really buy your product and tell how it was made, maybe it's that method of making it that is cheaper, faster, whatever than everybody else. It's better to keep that a secret than to file a patent application on that method and have to disclose it to everyone. So, and then patent, well, if it's an invention that appears patentable, and if it could be valuable to exclude others, or it could be valuable for licensing to others, yeah, file a patent application. And once again, these are things I talk to clients about. You have to, it's helpful to talk to a patent attorney or somebody has more experience in filing patents. What they think. Generally, trade secrets are good for methods that may not be as easy to protect with a patent. Patents are great for some sort of, basically a product that you're going to sell in the marketplace that somebody could just easily copy by looking at it. If you have a patent on that, you can go out and basically sue them and keep them from copying it. Publish, if likely not patentable, but you want to prevent others from possibly patenting. So this is something that comes up a lot in my area. People, they don't think it's worth filing a patent on something they've done, and they're not really sure if it's going to be that valuable maybe in the future, but they want to sort of prevent others from getting a patent on it. Well, once you publish it, it becomes known, it's out there in the world, and it becomes prior art. So somebody else coming along, if they were to file a patent application on that particular invention, the patent office during examination would say, look, it's already been described in the prior art. You can't have a patent on it. So you're sort of basically putting your invention out there into the public domain. Anybody else can use it, but they won't be able to get a patent on it. And summary slide here at the end. IP is valuable. It's good to protect. And there's a lot of different ways to do that. Processes for identifying, categorizing, monitoring, protection of IP are critical to companies. You should have some sort of process within your company or whatever it is, enterprise, to write down and record what you think is your intellectual property, and then discuss it internally and make some decisions about whether or not you're going to file a patent, or maybe keep it a trade secret, or publish it, things like that. So this last note here is really for the stage you're at. Once you have a going concern, you want to stay on top of IP that you're creating, because so often I'll go to a client and they will have done something years before and they never really kept track of it. Then they see somebody else is doing it. Uh, and it's like, oh yeah, we invented that, but they never did anything about it. So keeping track of your IP is just a helpful tip that I throw out there for you all. But I think that summarizes everything I have to talk about today. Uh, and I will leave it there.